Hello, and welcome to Barcast Audio. In this short audio, I'm going to briefly break down how to actually brief a case for your law school classes. Briefing cases is an indelible part of law school. It's one of those things that everyone hears about before they even sit down in a law school class. For some, the whole process of putting together these case summaries can seem daunting, unnecessary, and above all else, incredibly time-consuming. So I'll let you in on a little secret that most law students figure out sooner or later. Briefing cases is for suckers. It's a poor use of your time, and you should do everything in your power to limit how much time you're spending on it. You're probably thinking, but every law student in the history of ever has briefed cases, so how can it possibly be a waste of time? The answer is kind of complicated. While the actual act of writing out summaries for all the cases you read is a waste of time in most cases, the process of parsing out the essential elements of a case is both an important and incredibly useful skill to develop. That's why I'm a major advocate for book briefing. For those of you who don't know what book briefing is, it's when you essentially quote-unquote brief the case you're reading right within the pages of the textbook, usually with the use of different colored highlighters and margin notes or sticky notes. The process of book briefing allows you to save time when briefing cases without sacrificing the main drivers of briefing cases in the first place. That is, we still want to be able to pull out the pertinent facts, the issue, and the court's ruling. Issue spotting and identifying the key facts are the most important skills you learn in your first year, and the way you develop these skills is by reading through cases. Before you begin book briefing, it's important you have multicolored highlighters on hand. These will allow you to easily distinguish between the key facts, issue, and holdings as you read through the case. I suggest you work out a system within your head, identifying one colored highlighter as the issue color, another as the facts color, another as the holding color, and another fourth highlighter as the reasoning color. Ultimately, how you divvy these up is up to you, but the system that worked for me was yellow highlighter for the facts, pink for issues, blue for the holding, and green or pink again for reasoning. Let's move on to when you first open up your book and flip to an assigned case. The first thing I want you to do is to use your Fax Highlighter to highlight the court in which the case is being tried. Once that's done, I want you to use the same highlighter to identify both the plaintiff and the defendant in the case. I'll use the iconic torts case of Palsgraf versus LIRR as my example. There, the case was tried before the New York Court of Appeals, and the plaintiff was Helen Palsgraf. The defendant was Long Island Railroad Incorporated. Let's move on to the issue. The issue is the rule of law being tested. Usually this will come in the form of a question. For example, in the Palsgraf case, the issue is the question of whether the plaintiff, Helen Palsgraf, was a foreseeable plaintiff to the LIR's alleged negligence in pushing the man carrying the box of explosives. The issue is important because the court's holding on a particular issue is generally going to be where you pull your rule statement from when you're putting together your course outline for the semester. Next up, use your Fax Highlighter to highlight the key facts that are giving rise to your issue. So, in Palsgraf, this would be the facts explaining how an employee from the LIRR pushed a man holding a box of fireworks, and said fireworks ultimately exploded and caused an injury to the plaintiff. This would take us to the court's holding. This is generally a pretty straightforward yes or no answer to the question invoked by our issue. So, in this case, the holding was no. The Court of Appeals reversed the lower court's decisions and held that the LIRR would not be liable to the plaintiff. The reasoning, which I suggest you highlight in a different color from the holding, is going to be the court's explanation for its holding. This is the most important part, because it tells us why the court came out the way it did. So again, in Palsgraf, the reason that there was no negligence on the part of the LIRR was because they could not have reasonably foreseen that their employee's conduct would have resulted in an injury to the plaintiff Palsgraf. Note that you can also feel free to jot down anything you feel is hyper important about the case in the margins of the book. This may be helpful in easily keying into the facts of the case if you're the type of person likely to blank under the pressure of a cold call. That's it. That's all you need to know when briefing cases. It's that simple. One thing you learn through law school is the importance of working smarter over working harder. Book briefing is one of the best ways to get in the process of working efficiently, and a helpful way to avoid feeling overwhelmed by the prospect of briefing the copious number of cases you're faced with reading every week. Thank you for listening to Barcast Audio. Please subscribe to our channel if you'd like to see more of these helpful 1L tip videos. I'll be back with another tip next week. Until then, bye now.